Hey, it's Rob Ryder again on Saturday, February 13th, 2021, talking about the Land Act. And it is a law of the land. So every state's going to have some kind of land act, and what it will be doing is creating a PLAT, P-L-A-T, right? So a PLAT map, which appears to be basically the same thing as a cadastral survey, C-A-D-A-S-T-R-A-L, cadastral survey, which, according to the federal government, that if you have a cadastral survey with your name on it, full legal name, Robert Allen Wadlewski, well, then you're the owner of whatever that survey says is there, right? It's acting as your title. So, but part of this is that we don't, well, I don't have any, when I say we, you have to understand, I don't own any property, so I really can't be doing these things myself. But so we don't have the legal title. The legal title is with the state, right? What we have is interest. In fact, on your taxes, they call you the interest holder, right? And that's what they're foreclosing on, is the interest holder. The interest holder's interest in this property because the tax hasn't been paid. So this is kind of hard to believe unless you're actually looking at the documents, right? And it's, you'll have to go watch my previous videos that show all these things. But just listen to what I'm saying here for a minute, right? If you own land, or you believe you own land, that the real estate taxes you're paying, real property taxes, they're not really at all a tax by a government, right? It's people impersonating the government, counterfeiting tax forms that could be used in the proper condition, but, we're not in that condition because we don't have legal title. And so they counterfeit these forms and they simulate a legal process before an attorney at law, an esquire, who's pretending to be a fucking constitutional circuit court judge. But he hasn't taken the proper oaths of office, right? The oath in Title 4, United States Code, Section 101, 4 U.S.C. 101, which says all state officers, executive and judicial, shall, before executing any powers of their office, take an oath the following form, to wit, I, Robert Allen Wadlewski, do solemnly swear to support the Constitution of the United States. Period. Now, the state requires them to take another oath, but this is federal law. Federal government says you got to take this oath or you don't have any authority in the state. They didn't take it. Therefore, they don't have any authority. And, they need to stop now. Basically, quit acting like the government. But because nobody calls them on it, well, the shit continues on. And because there's these errors in the records at the township, we're really not in the United States jurisdiction because of the errors and omissions in the records of the frickin' plat maps, which, define who has title to the damn property. And we're not also registered as qualified electors of the township. So like my township, right, apparently its corporate name would be Township of Oakfield. Well, that's the thing I need to register with so I can vote as an elector for the people that are going to be on that township board, which is the township board of the Township of Oakfield. Now, if I go to a public meeting, when they say they have one, it's not going to be the township board of the Township of Oakfield that's going to be sitting there. It's going to be the Oakfield Township trustees, right? So that you're not going to the proper meeting for the electors. You're going to a public meeting for, something that isn't part of the franchise. And that's where the thing with the franchises come in. It's the local government that's supposed to give public utilities franchises within their jurisdiction. And in mine, when I look at the ordinance code, it says it's for electrical. It says it's Great Lakes Energy Cooperative or something like that, right? That they have they have the franchise in the township for electrical service distribution. But my meter and my bill are from Consumers Energy. And Consumers Energy put its meter in the section of the electrical service that they call the customer service. It's not in the utility service. It's in the customer service. So why is, Consumers Energy's meter in my service? Because they're not the utility. Right? If they were the utility, it'd be in the utility service. And it just goes to prove that, we're supposed to get electricity for free. We have to pay to have it distributed to us because you got to put up the poles and lines, that kind of shit. But that's what the franchise was given to the, this other entity for all the poles, the wires, so forth and so on. But I don't have a contract with them, right? Mine apparently is with the Consumers Energy. So I want to talk a little bit about that too. But let's talk about this act because it's very, very important. And before I can do that, I need to say, you really need to go back to Rob Ryder on YouTube, ROBBBRYDER, if you've not seen these videos, to get everything I'm talking about and start with classification, assessment, and taxes, right? Because I'm showing that in a guy in Dana's court case for foreclosure on taxes that they've counterfeited the petition and they counterfeited the notice that he was going to have these hearings. These are forms that are found on the Treasury local government website, right? I mean, this is local government official forms. They counterfeited these forms, changed them. Well, then it's not the Michigan Department of Treasury that's coming after you with their government, right? With their forms. It's somebody pretending to be them, using a counterfeit form to do it. And sure enough, that's what happens. The petition for foreclosure is supposed to be signed by a circuit court judge, but it's signed by a private attorney out of Lansing. And then I had just found recently that, it'll be one of the forms I'll be showing, that there's a appraisal form that's supposed to be done, right? That you should be getting it as the thing they call a property card. When you ask for it, they give you a property card that isn't the same, and it doesn't have the same information on it. And, these are the things that are keeping us out of the township. Now, how many of the people that work in the township are really in on the scheme? I don't really know. I believe most of them are just doing whatever they were told because it's the way it's always been done. But, the guy that has to know is the township attorney. So I say, well, the township supervisor should arrest the township attorney and don't let him go until he, gives up the goods, tells us how to fix the problem. Okay. Let me gather a few things here real quick. Hang on. So I just want to read the heading on the act to start with, and then we're going to skip around a little bit in it, and I want to get the good bits and pieces out first, which is mainly have to do with this assessor's plan. But this is what all this one act does, right? So an act to regulate the division of land, to promote the public health, safety, and general welfare, to further the orderly layout and use of land, to require that the land be suitable for building sites and public improvements, and that there be adequate drainage of the land, to provide for proper ingress and egress to lots and parcels, to promote surveying and monumenting of land subdivided and conveyed by accurate legal descriptions, to provide for the approvals to be obtained prior to the recording and filing of plats and other land divisions, to provide for the establishment of special assessment districts and for imposition of special assessment to defray the cost of the operation and maintenance of retention basins for the land within a final plat, to establish the procedure for vacating, correcting, revising, to control residential building development within floodplain areas, to provide for reserving easements for utilities in vacated streets, alleys, to provide for filing of amended plats, to provide for the making of an assessor's plat, which is our way to get out of this mess, and to provide for penalties for the violation of the provisions of this act, to repeal certain parts of this act on specific dates, and to repeal acts and parts of acts. So it's doing a hell of a lot of stuff, and all of it has to do with common law things. Right? You're talking about land, public health and safety, general welfare. That's all It's as common law as you can get. Same with drainage. This is, the drain commissioner. Our drain commissioner once said that the drain commissioner has more authority in the state than the governor does. So whether that's true or not, I didn't see what he means by that, but he said it, so he must know more than we do. And, all the way back to the 14th century, they had a court that was called the Court of the Pipe. It had to do with drains, right? Because you don't want to back up drains and have, you want sewer to flow the right way and so forth. So it's a big deal. To provide for proper ingress and egress to lots and parcels. And this is another big deal because they don't have your parcel hooked to the road. There's no driveway. There may be a drive, but it's not a driveway. It has to be a thing called a driveway. It's, that's a name. Driveway. It's not two words. No, driveway. It has a definition, right? And so it's not a drive. It's a driveway. One word. And you don't have a driveway on any map you have to look at that you say, well, here's the survey that they did when I had my property surveyed, right? It's not going to show the road or the driveway being connected to the road. So, that's how simple it is. An error or an omission in a record is causing all these problems. Surveying and proper monumenting a land conveyed by accurate legal descriptions, and this is the thing we're going to get them on, right, is because the legal description on somebody's deed, warranty deed, grant deed, whatever your state calls it, is not going to match the legal description that's being used on your taxes. Right? So there's two different legal descriptions. And because of that, we're going to have them get an assessor's PLAT because there's a discrepancy. So we'll look at all that in the act in just a second. But I'm just saying that look at all the stuff that's in here that has to do with common law type things. You got special assessments. Well, if you can tax, that makes you, that's one of the sovereign powers, the power to tax. Right, the power to tax, the power to police, and the power to of eminent domain are the three sovereign powers. So it's determining who has the sovereign power. Control residential building development in floodplain. Well, that's the Department of Natural Resource stuff, right? DNR. Right, that's the people that maintained the King's Forest back in the day. Right? They're the King's men. So we're dealing with people that are like the local version, not the King's men, just the local constables. And we need to get to the King's men. And so that the township is supposed to be your elemental republic. It's the way that Thomas Jefferson set it up. Right? And you would go as an individual to your local government to do all your legal business. You don't have to go anywhere else. They'll come to you. That's the way it's set up. Four levels of republic: the national, the state, the county, and the local. But for the individual, it's the local that you go to. Well, they have it all mucked up. There is no local. Nobody has a proper oath of office. These people, they won't let you register as a qualified elector in the proper township, which in my case, according to the ordinances, is the Township of Oakfield, Kent County, Michigan, United States. Instead, they have me in Kent County, Oakfield Township. Well, I don't want to be in that jurisdiction. Okay, and finally, I'm Staff Sergeant Robert Allen Ritluski. You probably already know that, United States Army veteran. You can call me Rob Ryder, and my email address is quarterrecord@aol.com. And phone number 616-712-6179. And it is your donations that keep my lights on. And like I said, I don't have any property people, right? But if we can get this figured out, it's going to set everybody free. So, you need to help me keep doing what I'm doing. So please donate. You can do it by PayPal to my account name as Rob Ryder at AOL.com, right? ROBBRYDER. Or if you want to use a credit card, then you could send me an email to courtofrecord@AOL.com and say, hey, Rob, I want to use a credit card. Give me an invoice for X number of dollars. And I would send you one through PayPal that you could use your credit card on. Or you could just stick it in the mail. Robert Allen Retluski, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341. Which is not necessarily my residence address, right? That's that's a physical address. If it was a mailing address, it would have, like Unit 55, which would be the last two numbers here, and then a 9-digit zip code. Do you know you actually have a 12-digit zip code, right? It's 49341, in my case, 8664, and then 55, and then a blank, but the blank is it is a digit that's counted in the 12-digit zip code. They're supposed to have some kind of controlling number or something in there. Anyways, nothing is really is how it seems, right? That we live in this fictional world, and we're just on the other side of the veil. And if you want to pierce the veil, you got to go to the township. So let's go see about doing that. All right, hang on a second. Alrighty, I'm not going to even try to read this whole thing, right? But I just want to point out that it does exist, right? It's called the Land Division Act, Act 288 of 1967. Again, this is for Michigan. But it has to do with, making plats, basically. So I want to first show you just some of the definitions. And so you find these same words used in your state law, that we're talking about the same thing, no matter what they call the act. But a plat means a map or chart of a subdivision of land. Land means land areas occupied by real property. Preliminary plat, well, that would one, before the final plat, I guess. Division, right, results in one or more parcels of less than 40 acres. And you got subdivisions, right, where now you got development that results in one or more parcels of less than 40 acres. Parcels mean continuous areas of land. Tract means two or more parcels. Parent parcel, parent tract, accessible. Okay. Has an area where a driveway provides vehicular access to an existing road or street and meets all the applicable location standards of the State Transportation Department, County Road Commission under this public act, which is like driveways, banners, and parades or something like that. Right, and I did videos on this 3 or 4 years ago, and I'm like, I haven't had a chance to go back and refresh my memory on it, but I just know that that had something to do with driveways, and that it is called a driveway. It's not called a drive. It's served by an existing easement that provides vehicle access. Well, there you go. Do you have a drive or a driveway? The way you know is if it's connected to the road or not. Lot means a measured portion of a parcel of tract of land, which is described, fixed or recorded plat, and fixed in a recorded plat. So there's something, right? The plat's recorded. Outlot, when included within the boundary of a recorded plat, means a lot set aside for purposes other than the development of a site, park, or other land dedicated to public use or reserved to private use. They'd be called private property. Proprietor means a natural person, firm, association, partnership, corporation, or combination of any of them that holds an ownership interest in land, whether recorded or not. And so, they call you the interest holder when you're being foreclosed on. So, but they're not using your name. This thing, there is an interest holder, and it looks like it's you, but they don't use your full legal name. This is what I was showing those other videos with Dana. Right? It's not Dana Reed Smith that's the interest holder. It's some number, and then Dana Smith, and then an address that's the interest holder. They create a thing out of parts of your name and put additions on it, and pretty soon it really has nothing to do with you. It's just letters that make up a string of letters. So governing body means a legislative body, a city, state, or a city, village, or township, board of a township. Municipality means a township, city, or village, right? And so there you are. You need to be registered in a municipality. County Plat Board means a register of deeds. Government survey means a land surveyed, subdivided, and monumented by the United States Public Land Survey, which is done in townships, right? Townships are the United States original jurisdiction. The Michigan coordinate system means a system defined by this. Oh, you know what that is? It's just another form of survey, but it's not quite the same as a public land survey. They had their own done. Right? The government survey is one that's done, by the public land survey, which isn't meets and bounds, it's townships. Health department means Department of Environmental Quality, City Health Department. I guess we all know what that means. So, they're involved in this. Okay, let's really quick now just go down to C. This is all talking about how you have one done in the first place, but we're past all that, right? We're really to this point right here. Assessor's plat. Assessor plat shall comply within some sections after this and may be ordered if any one of the following conditions exist, where a parcel or tract of land is owned by two or more persons. Well, I say yes, because the state holds legal title and you hold interest. There's more than two owners. You own different things in the same parcel of land. Right? But the next one, takes care of it, because it says when the description of one or more of the different parcels within the area cannot be made sufficiently certain and accurate, or are deemed excessively complicated by a governing body for the purposes of assessment and taxation without survey or resurvey. So the fact that the legal description is different on your warranty deed, grant deed, the deed you filed with the county, you say, well, that made me the owner, right? That legal description is different than the legal description used by the local government, township, on the real property tax coming out of the assessor's office. So, right? So somehow the assessor's not putting the right information. Now, how come he thinks he can do that? I don't know yet, but I'm going to say he can. Right? So let's get it figured out so it's all properly done, and let's have an assessment done. Okay, you got some other conditions you can get it done for. If all the other conditions are met. The plat shall be called an assessor's plat and given a name. It shall plainly define the boundary of each parcel, each street, alley, or road, and dedication to public or private use as such shall be evidenced by records at the Register of Deeds. Right? There'll be evidence. And the records of the Register of Deeds is evidence of whether there's a frickin' assessor's plat or not, and what its name is. Assessor's plat. The actual and necessary costs and expenses for making an assessed plat shall be paid out of the general fund of the city, incorporated village, or township whose governing body ordered the plat. Well, there you go. It's up to the township to pay for it. The proprietors of record of lands in the plat shall be notified by registered mail to their last known address in order that they shall have an opportunity to examine the map, view the temporary monuments, and make known any disagreement to the boundaries as shown. Well, all that information would be on the survey. Well, how would they do that, right? The proprietor lands. Well, who's on there now, right? That's what they're talking about. Who's on the paperwork now? Right now, you're not on it necessarily, but somebody could be. From 100 years ago. So there won't be anybody else that has any interest in it. It'll be concluded that you're the only person with interest in this land in your full legal name. Reconciliation of boundaries and numbering of lots within the plat. On every assessor's plat, as certified to the governing body, shall appear the bearings and the distances of the lines of each parcel recorded in the office of the Register of Deeds, and each lot shall also be numbered as provided in this act for final plats. And it's this lot number that I believe is used as part of your residence address that is the thing that they don't tell us, because they ask you for your street and number, when they ask for a residence address, and it's like, well, why is the number after the street? Right? So it isn't necessarily your house number they're talking about. It's this lot number. And so this is why we need the township to tell us what's my residence address, for this parcel, so that you can go then and get a freaking state ID that puts you in the proper jurisdiction. Okay, surveyor certificate, a sworn certificate of a surveyor who made the plat. Well, that's good, right? You're going to have sworn testimony. When completed, the assessor's plat shall be filed with the clerk of the governing body that ordered the plat. And under corporate area, the certificate of the county road commission shall first be secured, stating that the public roads shown on the plat were in existence at the time the plat was made. Okay, so who's got it? When completed, the assessor's plat shall be filed with the clerk of the governing body. Well, then it's filed with the township clerk. Right? What'd they say the town? I can't remember what they said the governing bodies were. City, township, and something else. But I don't know if they said county or not. Anyways, so it's easy enough to find out if it exists. Recording notification of local authorities. Appropriation of taxes. Reference to plat description. Reference to any land as it appears on a recorded assessor's plat is sufficient for purposes of assessment and taxation. Conveyance may be made by reference to the plat and shall be as effective to pass title to the land so described as it would be if the premise had been described by metes and bounds. The plat or record thereof shall be received in evidence in all courts and places as correctly describing the several parcels of land therein designated. After an assessor's plat has been made and recorded with the register of deeds, all conveyances of lands included in the assessor's plat shall be by reference to the plat. And the instrument dated and acknowledged after January 1st, 1968, partly to convey a mortgage or any such land, except by reference to such assessor's plat, may not be recorded by the register of deeds. To convey or mortgage any such land, except by reference to such assessor's plat, may not be recorded by any registered assessor's deeds. Well, people don't have that on their warranty deed. There's nothing on a warranty deed in Michigan that says that, it's tied to any assessor's plat. They put some legal description crap on there that, looks like it's done by public land survey, township survey, right? But there's nothing on there about there being any assessor's plat, right? So this is any time after 1968. So what I'm trying to say is when you go to the registry of deeds, they're not recording your deed. They may be filing your deed, but they're not recording your deed. Right? They'll put it on file till they get the assessor's plat figured out. Then you can, that can be made proper or something. I don't know, but you can see what's happening. And so again, well, why doesn't your warranty deed have this information? Well, because an attorney made sure it wasn't on there. That's why. It's a scheme. Right? Keep your legal name off documents, cloud the name of the property, and never actually transfer anything to anybody. Right? That's kind of what they want to do. So, hang on just a second, please. Right, so if you live in Michigan, no matter if you're being foreclosed on or late on your taxes or not, just the fact that you say that you own land, you need to go down and have them do an assessor's plat, because your tax bill, and this is the evidence you'll take in your tax bill, take in your warranty deed, and say, these don't match. Right? We have different legal descriptions. So it's not certain and accurate. And then you can go down here lower. I mean, you can easily just print this section out, take it in with you. Right, where filed with the clerk of the municipality, right? When completed, the assessor's plat will be filed with the clerk of the governing body that ordered the plat. So if they don't already have one down there, well, then there has to be one because of this right here that says any instrument dated and acknowledged after January 1st, 1968, purporting to convey or mortgage any such lands except by reference to such assessor's plat may not be recorded by the Register of Deeds. It has to be on there. There has to be an assessor's plat. And I'm saying there isn't. And I hope, somebody, so Michigan, please go find out and let me know. So I gave you my phone number at the beginning of the video. You have my email address, right? If you find this stuff out, let me know and let's get it fixed. Because we just have to find one township that wants to do it right. Right? Somebody who's ready to do the right thing. And once you pierce the veil, there's no going back. Right? All the rest of them will come into conformity after that, but we need one to pierce the veil. And you have every right to go down there. And if they won't do this, right, and there is no assessor's plat, then you can call the sheriff and say that you're being denied due process of law because you can't get your frickin' deed registered because of, Section 562.12 of the Michigan compiled laws. Right? Plats as evidence. You're being denied evidence. So think about that for a minute. Let me go get a few other things. Hang on here. Okay, I'm just talking about some other forms that are supposed to be around, right? This one is the Michigan Department of Treasury PTD 639 form, which is Residential Appraisal Record Card. Right? So this is supposed to be at the township. And if it was, it would have this permanent parcel number, which have the county, the township, the section, the quarter section, and then the parcel, right? It's a longer number than they're using. Right now, when you look at what they call the parcel number, it's got county, township, section, quarter section. But don't go all the way down to this last little part. It's got the property address, right? And then all of these blanks would have to be filled in. Got to have the name of the township or the county, whatever it is. Got to have the grantor and the grantee and the sale price. All has to be filled out. Well, this isn't the page this isn't what you probably get. What they're going to give you, they call a property card, that looks like this, and it looks something like the same. But look at this parcel number. Right? So there's that parcel number. What did this thing say to do for a parcel number? Right? It's got it split into groups. But that isn't what this one did. Right? And the grouping isn't the same as which is on this one here. Oh, I closed this somehow. Shit. Hang on a second here. So anyways, if this is the official form and they give you this instead, right, then this is a counterfeit of a state tax form. Because this came from the Michigan Department of Treasury. It's a freaking official form. It's like you can't counterfeit this. You got to use this form. You can't make up your own form. I don't have to agree with that. You're denying me due process of law if you're telling me that this form replaced this form. Right? This is my point. You don't have to put up with that. Call the sheriff. You're being denied due process. That's denial of due process. It doesn't happen in a courtroom. It can happen in a courtroom, but it can happen down the township hall too, because, hey, that's another kind of court. Right? It's just local jurisdiction. They made a decision that's affecting your life, liberty, or property. Well, it's time to pay the piper. Okay. Hang on then. I guess what I want to do then is I want to show another states real quick. So this is Illinois, right? And 765 ILCS 205, right? The PLAT Act, where it talks about it's using Illinois registered surveyors and what it's for and the basic stuff. Talks about monuments, what they're for. The monument must be furnished by the person to whom the survey is made, and it must be such that they will not be moved to frost. If a city, village, or town has adopted an official plan or part thereof in the manner prescribed by law, the plat of land situated within the affected area thereby must conform to the official plan or thereof, right? So if you're in a city, if they're saying you're in a city, then the city needs to have the plat, right? But if you're not in a city, then the township has the plat because the township was the original jurisdiction from which cities, were supposed to have annexed land to create themselves. The sale of a single lot. Oh, these are reasons that they don't have. These are exemptions, right? But they have to prove that they have an exemption. There's just a couple of specific things I wanted to show here. So let me go find them real quick. Yeah, I missed it here at the beginning, right? That whenever the owner of land subdivided it into 2 or more parts, any of which is less than 5 acres, he must have it surveyed and a subdivision plat thereof be made by the Illinois registered land surveyor, right? A particular kind of plat, a subdivision plat. Because later on, they're going to talk about what the owner needs to do when they trade. Here we are. When the owner is required to file a plat pursuant to Section 1 of this Act, the owner shall submit simultaneously with the subdivision notarized statement indicating to the best of his owner's knowledge school district in which the each tract parcel lot lies. In counties where the county clerk is not also the county recorder, a copy of the plat shall also be filed with the county clerk. Excellent. So no matter what, the county clerk has a copy of any plat that has to do with your property if you live in Illinois. Right? What plat? The subdivision plat. Right? This is about subdivisions. Each plat shall state a legal description or description sufficient to identify the boundaries of the annexed or disconnected territory by reference to government surveys, by meets and bounds, included section of township range. Okay, so this is when it's being annexed to a city. So if they say that you're in the city, right, then the land should be registered in the city now. So, like in Rosita's case, she believes she lives in the city of St. Charles. Do they have the plat? They're supposed to have the plat, but do they have the plat? If not, does the township have the plat? But if you don't know who else has it, well, the county recorder is supposed to have the plat. Or, excuse me, the county clerk. In counties where the county clerk is not also the county recorder, a copy of the plat shall also be filed with the county clerk. So it must be filed with the county recorder also. The plat must be complete. A statement from a registered land surveyor attached. An acknowledgement by the owner of the land or his attorney duly authorized in the name and manner of the deeds as required but to be acknowledged. School board. You got to contact the school board. There was something here about evidence. Where is that at? Use as evidence. Okay, so the statement of the registered land surveyor and acknowledgement together with the plat must be recorded by the land surveyor who prepared the plat or a person designated by the land surveyor, or upon the death, incapacity, and absence of the land surveyor by the owner of the land or his or her representative in the recorder's office of the county in which the land is situated. Or if the title to the land is registered under the Land Titles Act, they use the Torrens Act in Illinois also, must be filed in the office of the Registrar of Titles for the county, and such acknowledgement and recording of such acknowledgement and filing as for said shall have like effect as certified copies thereof and of such plat or of any plat heretofore acknowledged and certified according to law may be used in evidence to the same extent and with the same effect as in cases of deeds. Right? So this subdivision plat is the same as a deed, and if it doesn't have your information on it, well, then there's a conflict. So, it sounds to me like this already has to exist in Illinois. It's just time to go down and find out where it is. The acknowledgement recording of such plat or the acknowledgement and filing of the same shall be held in all courts to be a conveyance in fee simple of that portion of the premise platted as marked and noted on such plat. All right, there's your fee simple title. The acknowledgement and recording of such plat or the acknowledgement and the filing of the same. So what's the difference? I think the difference is acknowledgement recording is with the county recorder, and acknowledgement and filing is with this Torrens Act person, right? That you file with the under the Torrens Land Act, you don't record. And that's what they would do. They'd, do some screwy little thing like that, that if you don't understand that's what they're doing, then they're putting your stuff in the wrong jurisdiction. You don't even know what's going on. So, anyways, you're supposed to have a subdivision plan. And they talk about all these things you're supposed to do. Well, but this is what they do to you. Right? Instead, they give you not a subdivision plat, but a plat of survey. It's got a lot number on, so forth, and I wrote people's information in here. But it's not a subdivision plat. And if you look right here, here's a perfect example. Right here's where it says drive. The drive ends at the sidewalk. Everything in the boundary is, what they're saying is the property. Well, that property isn't connected to the road. So if you have this property's address on your driver's license, and you're in a car driving down the road, and you give it to the cop, he'd say, well, that piece of property isn't hooked to the road. You violated the common carrier. Right? You violated some highway act because you don't have proper ingress and egress to that particular address that you just gave them. So, they're substituting this, and they're acting like this satisfies the subdivision plat. So I'm going to have to look closer to find all the differences. I'm just saying, here's another thing that if this was being done right, well, then, the owner would be on this piece of paper. Right? I don't know. It'd be handwritten in like this. I think it'd be just as neat as everything else. I'd probably be down here in the margins someplace. Right? Not added on afterwards. So, there's no evidence that was put on there by the surveyor. Right? And that's what we're looking for. It needs to be things that the surveyor did. Okay, hang on. Just a few more things. So here's another example of, when legal descriptions don't match. Here's a thing called the plat of survey, and it's got, this long-ass description here of lot 162, unit number 6, Cambridge East, yada, 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 right? That's supposed to be the legal description. All right, but what were they using? What was that at? Not that one, this one. Right, this is the legal description that's on the assessment roll. Well, that legal description doesn't match, the legal description that's on the plat of survey. So why would you pay this tax? Right? That whatever this is attached to. It's got the address wrong or different. See, this is 1903 Rita Avenue, St. Charles, Ill. What did this one say it was? All right. It's got Illinois written out. It's not the same. So it's got Avenue written out. It's completely different. And so you don't have to accept these differences. You need to say, I'm being denied due process of law. Either fix it or I'm calling the fucking sheriff. And that's how to get fixed. Okay, and then just a bit on this franchise stuff, because it's a big deal too. That in the ordinance code for my township, it has Great Lakes Energy Cooperative Electrical Franchise Ordinance. An ordinance granting the Great Lakes Energy Cooperative its successors and assigns the right, power, and authority to construct, maintain, and commercially use electric lines consisting of towers, masts, poles, crossarms, guys, braces, feeders, transmissions, distribution wires, transformers, and other electrical appliances and facilities on, under, along, and across the highways, streets, alleys, bridges, waterways, and other public places, and to do a local electric business in the Township of Oakfield, Kent County, Michigan, for a period of 15 years. So as it turns out, that's running out this year. I think it was 2006, right? Township of Oakfield General Ordinances, adopted August 2006. So, right, the Township of Oakfield, Kent County, Michigan, is granting to the Great Lakes Energy Cooperative. So I said, well, I'm going to go ahead and contact them and then say, I just want to change my service. So I went to find their application. And instead, they have one for Great Lakes Energy, right? They don't have an application for this thing called the Great Lakes. Where the hell are you? Great Lakes Energy Cooperative. So, but what I do have is I have service with Consumers Energy, and on their application, one of the things that I asked for, right, as you're filling this thing out, is the site information. So the site address for service, and that's going to include the subdivision, development, and lot number. And I think this is the information that you would use on your state ID instead of your mailing address. Right? This has got all this site information on there. So now, when they send me a bill with service address on there, it doesn't have this information, the subdivision and lot number on there. So I don't really know what this information is on the service that goes to this property because it had already been created before I got here. I'm just saying, there you go, right? That they have this additional information they're asking for. And, here's another one. The same thing, the service address. They want the street address, the subdivision, and the lot number. So that's the proper information to be giving them, or it's already been given to them. So what is it? Because that's the information that you need to put on an ID card, I believe. Okay, I think that was about it, right? I just pointed these things out that, none of these other ones mean anything. Well, other than this, right? So the ordinances were with the Township of Oakfield, and yet when they're having a meeting, it's the Oakfield Township Board of Trustees. Well, what happened to the township, right? At the regular meeting of the Oakfield Township Board of Trustees, well, what happened to the, Township Board of the Township of Oakfield? When did they get together? So this is a, smokescreen meeting to go to. So there's lots going on in the background, folks, but it all started in your backyard, which is your township. And because there's errors in your assessment records, your tax forms don't match your warranty deed, right? You need to get the records created or properly done, and that requires a particular kind of survey that they're calling a PLAT. So whatever they need. And in Michigan, because you have these different legal descriptions being used right now, you should be able to just go down to the township with the, with the act and show it to them. Let me pull it up one more time so I can show it to you, and then we'll be done. Hang on. Yeah, if you're in Michigan, it's called the Land Division Act, Act 288 of 1967. You can find it without any problem, and then it's 38 pages long. Go to page 25, and that's where it starts talking about assessor plats. And really, that's the only part of it you need to take to the township to talk to them about. Right? Is the last bit, because all we're trying to do is get them to order the frickin' parcel or order the plat. If they won't do it, call the sheriff. Right? Because the parcel is owned by two or more persons. The state owns it, and so do you. And when the description of one or more of the different parcels within the area cannot be made sufficiently certain and accurate, well, it can't be because your legal description on your warranty deed doesn't match the legal description that's on your taxes, and the big one, so when I find that thing again, this section right here, this got to be the biggest, the biggest find I can think of. 562.12, MCL 562.12, references to plat descriptions, use plats as evidence. Any instrument dated and acknowledged after January 1st, 1968, which is most people's warranty deeds in Michigan, right? That's quite some time ago now. Purporting to convey or mortgage any such lands, except by reference to such assessor's plat, may not be recorded by the Register of Deeds. So the Register of Deeds is not recording your deed because it doesn't reference the assessor's plat. I can't, I've only looked at a few dozen, right? If you have one that has the assessor's plat on it, good for you. But I don't believe that your deed has the assessor's plat on it. If it doesn't, then it can't be properly recorded with the Register of Deeds. And so that's why there has to be an assessor's plat done, because you need it to record your fucking deed. So the person that's supposed to have it this is all at the township, right? Or the city, right? Whatever your local government is, they're supposed to have it. Okay, that's good enough for today. You'll have a great day, and hope you found it useful. Please go out and use it and let me know what happens. Very good. See you.